to the eNCA Money Desk now. We've got Rafua Matzena standing by. Rafua, more and more people are complaining about calls from telemarketers, and I'm one of them, actually. How does the POPI Act protect us?
Yeah, you and me both, Masako. Very good afternoon to you and all our viewers this afternoon. So yes, South Africans continue to be harassed almost daily by unsolicited calls from telemarketers. Now, many would have thought that since the Protection of Personal Information Act came into force 2 years ago, those calls would be a thing of the past. Not the case. Nomzamo Zondi, who is the spokesperson for the Information Regulator, joins us this afternoon to provide the clarity. Thank you very much for your time this afternoon. Perhaps just to remind us whether the Protection of Personal Information Act in itself outlaws telemarketing at all, or is there nothing in the law that prevents telemarketers from giving you a call at virtually any time of the day?
Good afternoon, Rafua, and good afternoon to your viewers. Thank you for having us. The Protection of Personal Information Act is actually in existence, and now that we have enforcement powers, it's to actually deal with such unsolicited calls that we are receiving, or as some would refer to them as telemarketing. So Section 69 of the Protection of Personal Information Act is very clear in terms of direct marketings by means of unsolicited electronic communication. So this obviously means that responsible parties who are public and private bodies are actually prohibited from processing personal information. When I say processing, either calling you or emailing you or faxing you or even marketing to you physically or personally. So it does prohibit that telemarketers or responsible parties to do that without your consent. Now, in terms of consent, we need to make sure that people understand that when you are consenting, it needs to actually be voluntary, and you have to have willingly given your personal information for you to actually be receiving those kind of telemarketing or direct marketing through any platform, whether it's email or SMS, etc. So, but what people, what responsible parties are currently doing, some of them are actually contravening the Protection of Personal Information Act and not considering that people need to consent and have to have willingly given their personal information for you to actually process it.
I mean, so you have received about 1,500 complaints from the public over the past 2 years, according to recent reports that we've seen. So what is the nature of those complaints, and what is the recourse that is issued by the regulator, the Information Regulator, when it comes to dealing with the contraventions?
So in terms of the complaints that we have been receiving as the Information Regulator, the vast majority of the complaints we do receive are in relation to direct marketing. And what we have been doing in terms of the complaints we've been receiving, we have been mediating and approaching the responsible parties who have actually been complained on. And in terms of why are they? Because what we need to do as the regulator, first and foremost, we need to ensure that the privacy of a data subject is protected. So we investigate what was the cause of this call, where were the contact details of this particular person received. So there are steps that we follow in determining what the nature of the complaint that has been sent by the data subject. So what you would find, Rafua, is that when we actually mediate as the Information Regulator, or we do conduct a pre-investigation, some of the responsible parties will then stop processing the personal information or contacting that particular data subject. So most of the complaints that we receive, the data subject, which is the person who the information relates, it could be you, yourself, or it could be yourself or me, and the person will then indicate that I've never given this company my contact number. And when I ask them where they got my numbers from, they either drop the call or they will then indicate that they received it from a national database. Now, what we've also noted in terms of the use of personal information without consent of people is that personal information is actually being sold by other responsible parties or companies. And that is actually in full contravention of POPI. And if a responsible party or a person is found doing such, they will have to face the full might of the law. So what we do advise data subjects is that when they receive these direct marketing calls or emails, they need to indicate to the responsible party or the company to stop contacting them, because they have every right in terms of the law to object from being contacted, which is the use of their personal information. And if the responsible party or that company continues or persists to contact them, then of course we do encourage people to actually lodge a complaint with the information regulator.
Does the information regulator, Nomzamo, have any authority to perhaps issue fines or any other stronger form of action against those who, as you say, worryingly even sell people's information?
Absolutely. So the Protection of Personal Information Act does allow for us to institute fines and penalties to responsible parties who actually contravene the Act. And since our enforcement powers came into effect, as you indicated early 2 years ago on the 1st of July, we actually have some enforcement notices that we have issued out to responsible parties, whereby they are found to have contravened the Act. So we do issue out an enforcement notice that clearly spells out what the responsible party needs to do. And if they do not abide by the enforcement notice, then we can actually institute fines up to 10 million or even imprisonment or even both.
Yeah, has this happened in the last 2 years since the Act was put into place, or have people complied when you approach them and issue them with an order to stop whatever it is that they would have been complained against?
Currently, we do have some enforcement notices that we have issued to a number of responsible parties. Of course, they are not so much related at this current point with the issue at hand regarding to direct marketing. Some are related to denial of access to information, and others, of course, in terms of issues of security compromises where personal information was then exposed, or if there were negligence or safeguards were not in place to ensure the protection of personal information. So currently there are enforcement notices that are at play, and assessments are continuing in terms of those responsible parties adhering to the enforcement notice. But of course, if they do not respond within the stipulated time that we have given them, we'll have to then institute those penalties and fines as I referred to.
And then just finally, Nomzamo, if you could just indulge us here, do you think that there's more that could be done when it comes to oversight and making sure that businesses or telemarketers and the like are complying with the law? Because you might find that a consumer will complain and block the number or give the instruction to never be called again, and that might not be that might not work for them, you know. So one would think, is there enough oversight as you see it at the moment, or could there more that could be done to ensure that there is a best way to counter these unwanted calls to consumers?
What we are doing as the information regulator currently, because we want to address this issue, remember that the information regulator is responsible to ensure and enforce compliance with POPI. So in doing so, we are in this financial year, as part of our program of action, developing a guidance note on direct marketing, because we also have a responsibility to educate and advise responsible parties on the implementation of the Protection of Personal Information Act, so that they can ensure the respect for and protection of this human right. So we are developing this guidance note, which is going to guide this industry or this sector on complying with POPI insofar as Section 69 is concerned, which speaks to direct marketing, as well as the ensuring that they do so in compliance with POPI and its 8 conditions. So currently, as I indicated, that we are grappling with this issue, and we have actually mediated a number of complaints with regards to unsolicited communication, electronic communication and direct marketing. And we are dealing with those complaints very seriously because we have had the plight of the public where they are indicating the frustration of this matter. So those responsible parties, where there's consistent complaints on them, we initiate our assessments at our own initiative just to investigate if that organization or company is actually compliant with POPI. And of course, once we do such investigation and that responsible party or company is found wanting, that can have reputational damage to that organization, or we'll also have to apply our enforcement powers with those companies. But we really are struggling with the issue of personal information that is being sold by certain individuals, and we are instituting investigation and assessment in this regard, and we're taking this matter very seriously. So we cannot express enough for the members of the public or data subject to come forward and report these companies who blatantly disregard the conditions for lawful processing of personal information as outlined in POPI.
Thank you very much for that clarity, Nomzamo Zondi, from the Information Regulator, breaking down the issues that exist and the work that the Information Regulator is doing to make sure that there is broad-based compliance in the telemarketing industry.